Ano naman ang gagawin ng employer if the employee can produce evidence that he's taking medicine, he's seeing a doctor, a physician, na totoo talaga, may condition siya. The key to addressing that kind of situation wherein the employee can really prove na meron siyang mental health condition is in the Department Order 208-20, no? And one of the possible solution is, of course, giving the employee a medical leave, no, for therapy purposes, or putting the employee or transferring him, reassigning him to another position. So there are many, many creative solution to the situation. And of course, another is you need to get a medical expert to be part of the solution. The medical expert will have to issue a fit to work, no? Kung walang fit to work, 'di ba? We cannot force the employee to work. So we need to have a medical expert for that particular illness to check the employee and determine fit to work, and kung fit to work, what are the works? What are the jobs? What are the activities or services that the employee can do? No, and find a compromise. Now, if the employee has to become part-time because of this, then that's another solution, no? That's another solution. So in other words, both parties, both the employer and employee, must work together to find a common ground, a common solution. Why? Because we have security of tenure. No, we have to respect what the law says, that the employee who is undergoing a condition like this has to be treated humanely and in consideration of his situation, condition, and also taking consideration his rights under the law, right to due process, right to security of tenure. However, also recognizing the right of the employer to have an efficient, well-oiled, streamlined organization that can deliver the expectations of its customers and clients. Importante rin po yun, no? Now, about illness. What if the mental illness of the employee is really such to the extent na talagang impossible na, no? Wala na talaga, walang maihanap na solution, no? Walang middle ground. So under the labor code, we have Article 299 that allows employer to terminate the employment of an employee who has a disease that is incurable for a period of 6 months, even though there is adequate medical treatment, no? If this condition is supported by a medical certificate from a public health authority, dapat po public health authority, meaning government, hindi pwedeng private. If there is a certification to that effect, that the disease is incurable for within a period of 6 months, even with adequate medical therapy or treatment, and it is prejudicial to his health, meaning not fit to work, and or not the other employees might be prejudiced if the employee is present in the workplace or rendering services, then that's a valid ground for terminating the employee. Pwede po yun, no? So there's a decision rendered by the Supreme Court. Try to read that case, Dioferio versus Intel Technology, a 2014 decision of the Supreme Court, wherein the Supreme Court allowed Intel Technology, the employer, to terminate the employment of Mr. Dioferio on account of his mental illness. Okay. Miss Sigrid, punta naman tayo sa next question.